Hey, 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 it's Ashley Goggins. It's Free Game Friday. Happy Friday. Super excited that you're joining us. Go ahead and share this out with any fathers that you know. Tag them. Share it on your page with your brothers, your cousins, your boyfriends, your husbands, your dads, your baby daddies, whomever you know that has children that needs to know this information. Again, guys, I'm attorney Ashley Goggins at Ashley Goggins Law. We specialize in family law matters, divorces, paternity, child support, child custody, criminal law, and personal injuries, specifically auto accidents. But today is our Free Game Friday, and this is our special Father's Edition. So this is for any fathers that you may know. So I'm going to take this time to share this out on my personal page right now. Share it out, share it out, share it out. Okay. Share now. So we have a question of the day, and tell me where you guys are tuning in from. I know people in several different states. Right now, specifically, I am in the state of Florida, so the information that I will give will be specifically geared to the state of Florida. This will not be any legal advice. I love y'all, but I am not your attorney, and I'm not providing legal advice, but I will do the best that I can to help you. If you want to schedule a consultation, please schedule it with me if you are, again, in the state of Florida and you need some assistance and some legal advice. That is the proper channel. All right, so let's get started. So today's question, Free Game Friday. Today's question is, it comes from a father. He submitted this question on live through the Free Game Friday link that is in the bio. The question is, my baby mama and I agreed to $300 per month for child support. Do I still need to open a case? Can she take me to court? Okay, this is super common, Okay, so this father is paying his baby mamas. Maybe they have agreed, they have a good relationship, a good co-parenting relationship. They are grown-up adults and they came to an agreement. Look, I'm going to pay you $300 for the child's care or whatever the child needs, food. So the first question is, do I still need to open a case? I would say to protect yourself, if you want to be protected, then yes, you would still need to open a case. And here's why. Here's the reason number why you should open a case. A lot of times when a mother takes a baby daddy or a boyfriend or ex-husband to court, they ask for something called arrears, okay? They ask for something called arrears. Arrears is retroactive child support, okay? It's retroactive child support, meaning child support before the petition was filed, child support before any action as a part of the course. And before, this retroactive child support could go all the way back to prenatal care, all the way back before the child was born. A mother could ask for all of that money to be paid back. Now, right now, what you're doing is just gifting. You're gifting the mother money right now, technically. You're gifting the mother money, you're providing her assistance for the child, but it is not legally child support. So when the mother goes to court and she puts you on child support, she could ask for retroactive child support or child support in arrears in Florida for the last 2 years. It used to be up until the child was born, but now it's for the last 2 years, okay? The last 2 years, that's the maximum time that retroactive child support. So you could be paying your $300 every month on time, every year on time, and she could still come in there and go to court and say, look, I still want my retroactive child support. And there are some judges that would award her that retroactive child support because guess what? You're just gifting her. You're just gifting right now, okay? So again, if you want to protect yourself from those arrears, which is the main reason, and the courts encourage mothers and fathers to come to an agreement, and that is great. That is great that you guys have come to an agreement. Now, another thing, on the flip side, if you're paying her $300 a month right now, and you make significantly more than her, or she is unemployed, then that $300 may be a gift, okay? So maybe you should beat her. You know, you should beat her asking for it. You should be at her house with the signed check, and we're going to get into the method of how you should be providing assistance if you don't have a court order. So you should literally have this in her bank account before the first of every month if you do make significantly more than her, because that $300 may be significantly less than what you could be paying in light of salary. Because as we talked about last Friday, what child support is based on your income as well as the mother's income, okay, and how much time each parent spends with the child. So you want to make sure that you are covering your bases, okay? And so let's talk about covering your bases. Father, you're paying $300. How are you paying it? So are you giving to her cash? Are you giving her a check? Are you transferring the money in her bank account? Are you giving her a money order? This is how you should be paying. So this is a tip number 2, okay? Tip number 2. If you are going to pay in this method or manner, you need to make sure that you are using a check or you are using a money order, okay? And it's specifically on the memo line of the check or the money order, you need to make sure that you put child support for little Deontay, child support for little Brian, child support for whatever your child is, child support for Desiree, child support for Alexis, okay? You need to put the month. So I would put child support, little Deontay, Mackenzie, Alante, Fuller. And I would put January 2018. That's what I would put on the memo line of every check or money order that I provide, okay? Everyone. I would have a bank account specifically for me to pay child support out of that bank account, and I would have personal checks that I make out to her, because you know what, if you have a bank account, most of the times with the digital age, you can see digitally all the checks. So when it comes down the line and you may have to go to court, you can just go with the click of a button and print out all of those digital checks. If you got Bank of America, print out all of those digital checks and see when they were cashed. So she, being the mother, cannot come in there and say that you have not been providing child support during the child's life prior to that petition being filed. So you want to make sure that you are protecting yourself. The last question, can she take me to court? Absolutely. She can take you to court and she can start a case. She can still take you to court, and your payments may go up, your payments may go down. It's going to depend on, are you asking for a parenting plan? Is she asking for a parenting plan? It's going to depend on how much she makes, and it's going to depend on how much you make. Because again, that's what it's based on. The incomes of all parties that are involved and how much time you spend with the child. So there may be a situation where just based on the calculations, you may have to pay more than $300 a month. Or if she takes you to court, you've been providing for your child, you want to spend just as much time with your child as she does, then you may break even and you may not have to pay her anything. But it's just going to depend on the situation, how much time each party is getting, and how much you guys make. Does anybody have any questions specifically about that, okay? I hope that I answered your question about you paying your baby's mother, your child's mother. It could be your girlfriend, because I have had several occasions where girlfriend and boyfriend are, he's still providing assistance to her and a set amount, or put himself on child support while they're in a relationship. So that does happen. But I would just say kudos out to the father and the mother, because I just feel like if you can get it done without going to court, then that's great. You know, but make sure you're protecting yourself, and going to actually get a court order is most often the best way, or at least consulting with an attorney to see what your options are, because a lot of times, you may end up paying more, or you could end up paying less depending on the situation. A cease and desist to the plaintiff party. Can you be more specific? And in family court, it's the petitioner, that's the person that's filing the petition, and then it's the respondent, the person that needs to respond to the petition. So if you guys know anybody, if anybody has any questions right now about anything I said, please put it in the comments below. I'll answer your questions if it's about your child support, if it's about custody, time sharing, retroactive. So make sure you're protecting yourself. Those are the two takeaway points from today's lesson. Look, make sure if you are paying child support and you don't have a court order, make sure that you are documenting it, because you want to protect yourself and defend yourself against retroactive child support, okay? So document everything. Document everything. Keep your receipts. Have a bank account that's specifically for that child. And again, you need to consult with an attorney, because what you're paying now, you know, you don't want to just hop and say, look, I want to open up a case. I want to, you know, put myself on child support, because you may be better off not putting yourself on child support, because the amount that you're paying now could be way less than what you may have to pay. And it may be best for you guys to work it out outside of court and come to some type of negotiating agreement. So you want to make sure what's in your best interest. Now, we do have some fathers that are paying significantly more than they would be paying, because they're spending a lot of time with the children. They have the child. They have equal responsibility in the child. So a lot of times that decreases the child support when it comes to a time sharing or parenting plan. Well, thank you guys for joining me again for our second Free Game Friday. If you have any questions or you want one of your questions answered on Free Game Friday, please click the link in the bio. You can submit your question there, and I would love to answer it here live on Free Game Friday. Please share this out again with any fathers that you know, any fathers that you love, any fathers that you trust, any fathers on your timeline that you know. How would the mother end up paying the father child support? That's a great question. Actually was going to talk about that a little next Friday, but briefly, the same way. If the father has majority time sharing with the child, if the father has 60% of the time, or the father has 70%, the mother has 30%, then the mother may end up having to pay child support if she has the ability to pay. Okay, they have to have the ability to pay. So maybe she makes significantly more. She could be making more than the father, but the father has the child most of the time, so the roles are reversed in that regard. Yeah, so I would say it's really just going to depend on the amount of time. So there are 365 days in the year. 50-50 or split joint custody is 180 days, 180 overnight visits with the mom and with the dad. Now, what offsets the child support is if one of the parties makes significantly more than the other party, even if it's 50-50 custody, sometimes one party will still have to provide child support. But say the father had the child, you know, maybe 200 nights, and the mother, they probably made the same amount of money, or she made more, then the mother likely will have to end up paying some child support. So it really just depends on how that time is split up, as well as the income of both of the parties. Hope that answered your question. Jeremiah, that looks like it's a civil issue, and this is not a civil issue, Free Game Friday, and I'm not sure what you're asking. Good, Ranisha. So again, I will see you guys later. Thank you guys for joining me. If you want to schedule a consultation, please call my office at 904-903-4522. And always remember, go with Goggins.